Gentlemen, now I want to introduce you to Kristen Catasus. Kristen is an associate at the Gray Robinson Law Firm, which is a nationwide alcohol beverage, part of the nationwide alcohol beverage practice. She works with Elizabeth DeConte's group at Gray Robinson. Kristen focuses on a federal and state trade practice compliance, sales, marketing, advertising, as well as licensing. She also spends time in the food law area and cannabis. She has assured me that she's not going to make this a alternative to smoking marijuana seminar, but no, actually, she's here to talk to us about compliance in that three-tier system that we have in the United States. Ladies and gentlemen, please welcome Kristen Catasus.
Good morning, everyone. Thank you for having me today. I'm here to talk about alcohol beverage. Our practice group does focus on multiple regulated industries, anything that's going to have any sort of government oversight: cannabis, tobacco, food, cosmetics, gaming, gambling. But I think of all of the regulated industries, alcohol really is my favorite. And I feel like alcohol is really unique because if you are someone who is in the alcohol industry, you're dealing with this on a daily basis, you know how the trade practice works, these laws make absolutely no sense still. No matter how hard you actually try to get into the industry and how long you're in it, laws are changing, people's perceptions of alcohol change. And so it's always a moving business. You never really know what you're going to get when you step into it. So you can go ahead to the next slide. So when you get into the alcohol beverage industry, one of the terms that's going to come up that you might hear a lot is called tied house. Tied house was actually a term used to describe English pubs when they were operating and they were required to buy their beer from a specific brewery. The retailers were, in a sense, tied to the producers. And this led to a really large market domination of producers who were offering loans, outright owning retail establishments. And then that's when you see things kind of, creep into America and into the bars in America, and what led to this great failed experiment of prohibition. You had excess and overconsumption, and that's when the 18th Amendment came around and prohibition cut everything out. Obviously, as we all know, that didn't work out too well. People loved their alcohol, they wanted it back. So much to the point that we actually had to make a constitutional amendment for it. So with the end of prohibition, alcohol was reintroduced with a little bit of a different concept. The US government came back and said, okay, in order to avoid these criminal tendencies that took place, previous to prohibition, when everything was overrun, we're going to introduce the Federal Alcohol Administration Act. This does a couple of things, but for our purposes here today, it really accomplished two main things. It established a three-tier system. So alcohol distribution today, you're going to see it operates on three distinct tiers: your manufacturing tier, where all your alcohol is produced, your wineries, your breweries, your distilleries. Your next tier is the wholesaling tier, where your distributors and warehousing. And then your third tier is the retailers. And this is your on-premise, off-premise, hotels, industries that are selling directly to the ultimate consumer. And I'm going to assume that that's probably the majority of you here today as part of the hospitality industry. You're going to fall into that third tier of retailers offering alcohol to the end consumer. And then the other thing that the FAA Act did was it establishes and regulates trade practices amongst those three tiers. So we're going to get into a little bit more of that on the next couple of slides, where we're going to see what those trade practices are and how you can best regulate them. So you can go to the next slide. So when you consider alcohol, you first want to ask yourself, okay, I'm in the alcohol industry, who is regulating my industry? And I think a better question to ask is who's not regulating it? Is a very, very regulated industry. You're going to have oversight at the federal level. This is going to be done by the Alcohol, Tobacco, Tax and Trade Bureau. They are tasked with enforcing the FAA, and a lot of the regulations are going to come from the CFR, the Codified Federal Regulations. At the state level, it's going to get a little bit more complicated because the states have been granted power to regulate alcohol amongst their own borders. They can really decide who they want to oversee alcohol regulation in their state. So you're going to see it's kind of, some states are going to strictly apply it to their alcohol beverage control authority. Some of them are going to give that power to the office of the governor. Some are going to give it to the state attorney's office. Sometimes it's going to be split, and you're going to have one agency that controls the regulations, your statutes, and you're going to have another agency that controls the enforcement of it. You're going to have police powers that actually can go in, and they have police power in different retail establishments. So it really kind of runs the gamut depending on what state you're in. So it's really important to know who your controlling authorities are in the state in which you're operating. And then also at a local level, a lot of places are going to have a lot of local oversight too. In some states, they are called dual licensing states. And in order to operate at a retail level and sell alcohol, you have to be licensed not only locally, but at the state level also. And a lot of that regulation is going to come from the local level, local approval, local government, public hearings, making sure that you can get in and get that license, because the state won't issue it without the local approval. And then another thing that you're going to want to look out for is all of these emergency orders that we're all very familiar with over the last couple of years. These come out at the state level and at the local level, and they have the power to change the laws very quickly, especially in alcohol beverage. A lot of things in alcohol beverages, you cannot do this unless there is an exception. And sometimes these emergency orders will come out with very narrow exceptions, with a very unique time frame of only, until the end of the month, until the 30th of next month. So it's really important to keep an eye on all of those stagnant regulations, as well as the new ones that are developing over time and come out on a rolling basis. The next slide. All right, so going back to the trade practices, there are 4 main trade practice violations that you want to be worried about when you're working in the alcohol beverage industry: tied houses, exclusive outlets, commercial bribery, and consignment sales. So tied house is essentially a form of market manipulation. These 3 tiers that we talked about earlier, the manufacturer, the wholesaler, and the retailer, they're required to operate independently of each other. The US government does not want to get into that instance they had before Prohibition, where manufacturers could offer money to retailers, could outright own retailers. They want to make sure that all of those are completely separated now. So the first concern is these tied house laws. And the tied house laws make it unlawful for any supplier or wholesaler to induce a retailer to purchase alcohol beverages. And that can be a really broad term when you hear the word induce. When you walk into a store and someone offers to sell you something, is that an inducement? So some of the examples that you're going to see in alcohol beverage of what they consider to be an inducement is providing free labor. If a manufacturer or a wholesaler wants to come into your business and say, hey, let me restock these shelves for you. Let me clean up around here. That's providing free labor. That is a tied house violation under alcohol beverage law, which is kind of unique, because when you think about any other industry where you have someone coming into your business and offering a service, that's not a crime. But under alcohol beverage law, it actually is. Paying for entertainment, guaranteeing a loan, repaying a retailer's financial obligations. All of these are tied house violations that are going to put your license at risk, have you face fines, and in some cases it can end in criminal violations as well. The next one is exclusive outlets. This finds that it's unlawful for an industry owner to require a retailer to purchase alcohol beverages. This is any type of agreement between a manufacturer and a retailer, or a manufacturer and a wholesaler that's going to require that retailer to purchase alcohol from them and not from anybody else. This is such things as a purchase agreement. It can be you see, like, a lot of those old 1920 movies with threats and coercion and I'll break your legs and all of that stuff. Amazingly, it actually still does go on today. I have seen some violent encounters when it comes to collecting alcohol payments from different retailers and from different wholesalers. But most of this is going to come down to agreements. And this can be written agreements, verbal agreements, a wink and a nod agreements. Anything that's going to require a retailer to purchase a certain product is going to be considered an exclusive outlet, and it's going to put your license at risk. The third is the commercial bribery. This makes it unlawful for any supplier or wholesale to induce a trade buyer to purchase alcohol from them by offering bonuses, premiums, compensation. An example of this would be, a manufacturer coming into your business and offering your staff gift cards in order to promote their specific product. Things of value to officers coming in, sliding some money or sliding some gift cards to the manager of, a really nice restaurant that's opening in downtown. Giving them, quality bottles of alcohol that might not be available to the rest of the public. Anything that's considered bribery, anything to get you that extra step is going to be considered commercial bribery and a violation of the trade practice laws. And then the last one is consignment sales. Consignment sales are illegal in alcohol beverage. There are very few exceptions when you can have a consignment sale. Consignment is basically the sale of alcohol with the privilege of return. So this is a wholesaler comes into your business. They want to make you this great deal. You have to buy all of this product. You're not really sure if you're going to be able to resell it. And they say, don't worry about it. You don't have to pay me now. Once you sell it at retail, then you can pay me. That's a consignment sale violation, and it cannot be done in alcohol beverages. So those are the four main concerns under trade practice law that you really need to look out for. And like I said earlier, I'm sure a lot of you in this presentation today fall into that retailer tier. And you hear me talking about these violations about, tied house violations against a retailer, exclusive outlet against a retailer. And you're thinking, I'm not really, hearing of any retailer violations here. These are all crimes being committed against me as the retailer. And you're right, at the federal level, actually, the federal government only regulates activities by manufacturer tier and the wholesaling tier. So yeah, you might be clear, in federal terms. However, your issue is going to really pop up on this next bullet point, state cooperation. When you offer someone a bribe, you can't really offer a person a bribe if they don't accept that bribe. There has to be someone who offers it and someone who accepts it. So under federal law, it's a violation for the manufacturer to offer that bribe. But under state law, it's going to be a violation for you as a retailer to accept that bribe. So your issues are going to really come in when the federal government and the state government actually decide to get along, which they tend to do sometimes when tax dollars are involved. And they set up these joint investigations where the federal government, they might not even be looking at you as a retailer. They might be looking at your supplier. They might be looking at your wholesaler. They might be looking at a third party that's just coming in and setting up an event on your premises. But your relation to what is going on and what their investigation is could unwittingly just swoop you into that investigation. And the federal government is more than willing to push that off on the state, give them all of their information. And the next thing you know, you're wrapped up in a state investigation that was a tailspin off of this federal one. So that's where you really want to be concerned and worried about how you're operating and who you're operating with. It's not just about, oh, the manufacturer's doing this, I don't need to worry about it. You do need to worry about it from your perspective as well. COVID-19 procedures. We all have seen how much that has really impacted the hospitality industry in the last couple of years. Like I said before, with emergency orders rolling out, and especially in the last couple of months, here in Florida, I know a lot of emergency orders have actually stuck and become law, such as delivery of alcohol beverages. So it's really important to be up to date on those. And then what is required during an investigation. There are statutory requirements for any time there's an alcohol beverage about what kind of records you as a retailer, you as a wholesaler, you as a supplier are required to keep. Sometimes they can be digital, sometimes there's actually physical paper requirements, and they have to be kept on your premises and available to be reviewed. So it's really important to just be up to date and know this is where I'm located, this is what my local requirements are, this is what my state requirements are, and to just be prepared, because there is the ability of those state agencies, police powers, to come in and demand to review those records and to see what you have been doing and to review your invoices. So next slide. So what is being scrutinized when they come in and they review your records, or you get a call from TTB or you get a call from the state agency asking about what you've been up to? These are the kinds of things that I have seen in the last couple of years that really stick out. Slotting fees. This is for anyone who has ever gone and sat down in a restaurant and ordered a Coke and the waitress says, "Is Pepsi okay?" Coke and Pepsi are allowed to go into different retail accounts and pay the retailer to exclusively show their brand or to exclusively display or serve their brand. An alcohol beverage, that is a huge no-no. You cannot have exclusivity in alcohol beverages. Anytime that you see one brand being offered, there have to be competitor brands also being offered. Sponsorship agreements, alcohol delivery. This is a big one after COVID-19. Many states are making those emergency orders permanent, allowing alcohol delivery, but there are a lot of restrictions around them. Who can make that delivery, how the identification process has to take place, being able to provide a virtual copy of your ID before having your purchase take place. There's a lot of restrictions surrounding this, and because there's a lot of restrictions and it's very new, there's also going to be a lot of oversight. So you're going to want to make sure you're doing it right. Use of third parties. This is a big one I've noticed in the last couple of years. A lot of state agencies are cracking down on these third parties. A good rule of thumb when you're operating in the alcohol beverage world is if there is a practice that you cannot do yourself, you cannot hire a third party to do it on your behalf. We've seen this a lot where, retailers or wholesalers will hire a third party to do something that they can't. If you're a retailer and you want to hire a third party to make your alcohol deliveries, if you're a wholesaler and you want to hire a third party to go into the retail account and offer a sampling, in your mind, you might have an agreement with them. You push the work, you push the worry off on this third party that takes care of this for you. But what's happening is these third parties are kind of operating without any oversight. They don't have licensure in alcohol beverage. They don't really have any skin in the game. So when they're sitting and doing these tastings, or when they're doing a delivery and they don't have any kind of oversight, if they get caught up doing something illegal in the alcohol beverage realm, the state agencies, they're going to start their investigation. They're going to look at these third parties, but they don't have a lot of control over what those third parties do because they're not licensees. So what they're going to do is they're going to look at, okay, who is ultimately behind that third party's actions? Who hired that third party? Who has a license? Who can we go after? And that is where there's going to be concern, because it's going to be your license on the line. When you hire a third party to act on your behalf, even if you don't know what they're doing, you might have no idea that they have an improper delivery. But them acting on your behalf is going to ultimately make you liable. Entertainment on licensed premises, incentive programs, and again, COVID-19 procedures. I can't stress enough how important they are because of how rapidly they are changing. Next slide. Right. This slide is just to kind of give you a little bit of an oversight of some of the previous violations and non-compliance and how it can affect your business. You can see in one of those first ones here on fines and offers and compromises. This is kind of an example of some retailers who got caught up in an investigation that was ultimately against a wholesaler and manufacturing tiers. This was TTB going in and finding that the wholesaler was manipulating retailer incentive programs. And so that's a violation against the wholesaler for manipulating those programs. But ultimately, those 20 retailers had to be a part of that incentive program. They had to accept the incentive. And so that was a violation of New Jersey law. And those 20 retailers ended up paying a combined $2.3 million for the role that they played in it. A little bit further down, you'll see an example of TTB accepting a $2.5 million offer and compromise from a beer manufacturer. And this came from a joint investigation. So this was actually TTB teaming up with the Florida Division of Alcohol Beverages, the Miami District Office, Washington State, New York City. So now you're seeing, this joint investigation between local enforcement authorities, state enforcement authorities, federal government, all going after and ultimately getting $2.5 million from an illegal actor. And then you can see these suspensions on the bottom here. This is the examples that I was giving earlier about all of these COVID-19 restrictions being in place and why we need to really be up to date on them and know what they are, given that they're rapidly changing. In Texas, the state beverage authority did a sweep of 1,700 bars and just started handing out warnings, 30-day suspensions, 60-day suspensions on different licensees that were violating the emergency orders currently in place in Texas at the time. And if you're in the hospitality industry, and even if you're a small business or a large business, you know how much shutting down business for even a couple of weeks can really impact your annual goals. So having enforcement agencies come in and shut down your license and ability to operate efficiently for any period of time is not ideal. So these are just some of the examples of, what could ultimately end up happening to you if you're not vigilant in enforcing these alcohol beverage laws within your organization. Next slide. And then finally, this is just a little summary of what you can do to make sure that you are enforcing these trade practice laws. If you don't know what the law is, you need to find someone that does. There are a lot of times when many clients come to us and it's kind of at the point where you're reacting to something that's already happened. There's already an issue in your business. It's best to have that done ahead of time. It's best to have, an attorney on retainer. It's best to educate yourself ahead of time and be reactive to the problems and know, what am I getting into? Where are the pitfalls? How can I react best to this? And how can I make a plan going forward to where this doesn't become an issue for me? Internal education and compliance programs are a huge, huge thing. I know a lot of clients who don't like to think about spending the money on, having internal education and compliance, but I can tell you at the end of the day, you're likely going to spend a lot less money on internal education and compliance than you will on a fine at the end of the day, or the suspension of your license and loss of a certain profit in your business because you were not operating in compliance with alcohol beverage laws. Document everything. Like I said, there are statutory requirements for documents you can keep, but having those documents and having your receipts of basically everything you've done can really help, if not completely absolve you, at least mitigate any of the circumstances when you're being investigated and you're able to justify certain payments or certain expenses to a regulator that comes into your office and sits down and starts flipping through all of your books. If you're someone who really has your books in order and are able to show where those payments were made and where they went to, that's going to go a long way because a lot of these investigations are very discretionary. So, being amendable and being helpful and having those in order might go a long way in helping you in getting through that investigation. Management companies, concessionaire, and sponsorship agreements, those are really good things to have reviewed. You want to be very careful about what's written in those agreements and how it's written. That's why I strongly suggest having an attorney, at least if not draft, at least review those agreements to make sure that they are written in a proper way. Because if there is an investigation for something that's gone wrong, those agreements are going to be turned over to the investigating agency to be able to review and see what was actually agreed to and written down in terms. And then finally, voluntary disclosures. That's something that you're going to want to discuss with an attorney. If you feel like you might have done something wrong, if you're not really sure and you want to weigh your options, many states do have voluntary disclosure programs where you can tend to avoid a fine or hopefully mitigate what a fine might be if you are forthcoming and you have those kinds of conversations ahead of time about, this is our plan going forward. Here is our internal education that's in place, and here's how we plan to resolve and be compliant going forward. And then the last slide. So again, this is my contact information. Thank you for having me here today. I appreciate the ability to speak on this topic. As a very fun one for me. I've been lucky enough to be able to operate in all of the different tiers of alcohol beverage so far, and the manufacturing tier and the wholesaling tier. And now I work primarily with retailers here at our alcohol beverage group. So I'm happy to address any questions or comments that you might have.
Thank you very much, Kristen. That's very interesting information and some very helpful tips. Just to start us off on the Q&A, I just want to make sure that I have this right. On the discrimination in the civil rights area, the judges are often right. You cannot do indirectly what you are prohibited from doing directly. And it sounded to me like that's what you were also saying in this alcohol space. Is that a fair way to characterize it?
Absolutely. We'll see a lot of the laws will actually expressly say cannot directly or indirectly. That's where you see a lot of the pitfalls in the last couple of years with these third-party, you typically call third-party marketing companies. It's kind of been a way recently where alcohol beverage operators have caught on to the fact that, oh, I can't offer you money, I can't do this. So they kind of, use these third parties as a funnel. They'll say, I can't pay the retailer, thousands of dollars to have a band perform at their event tonight, but I'm going to go to this marketing company. I'm going to pay them $20,000 to help promote this event. And as part of promotion, they're going to slide a couple $1,000s to the retailer. That's going to ultimately be traced back, and that is going to be considered an indirect payment from the manufacturer to the retailer.
Yeah, very helpful, because there's a lot of these arrangements out there that do try to circumvent that. So it's going to be interesting to see how that is enforced and comes around. Let's see, we've got a question here. How do alcohol manufacturers get the word out to retailers to buy their product if they cannot technically induce sales? Are there special FTC advertising protocols for alcohol manufacturers in particular?
There are. So it's not under the FTC. It will be under your state regulatory authorities. So when you go on to your particular state or even your particular locality, there's going to be statutes and regulations. And so basically what happens is there's a federal umbrella that says, here are the violations. Here are the things you cannot do. You cannot induce. You cannot offer a bribe. You cannot force anybody to buy alcohol. And then when you get into the state laws, the states are going to go back through and they're going to define what those terms actually mean. So in Florida might say, you can put a retailer's name on signage. You can say my product is available at this retailer, and this retailer. Make sure you stop by and buy it. And Florida law might say, we don't consider that to be an inducement. If you list at least 3 different retailers, that's okay. But if you're operating in a different state, say you're operating in South Dakota, maybe, South Dakota might decide to change what that definition means. South Dakota might say, We don't think that that is permissible. You cannot list 3 retailers. You cannot list retailers at all. You can just advertise your product. So that's why it really depends on where you're operating, because the states have the ability to basically, the law itself doesn't change, but how that law is defined is what does change. So there are ways to promote your product. Generally, it has to be very, very an abstract promotion, promoting your product, having a Bacardi commercial, having a Diageo commercial, having a Grey Goose commercial, and not necessarily saying, hey, go get, X product at ABC liquor store, go get X product at X restaurant. It has to be very general terms.
That's very helpful. We're out of time, but Kristen, I was hoping in the chat you might post an example of how we could get ourselves in trouble with these third-party management or concession agreements. Could you just list an example or two in there that you've had some experience with, so people could be on the lookout for those, or what you see as the most common challenges? Just a couple. I think it'd be very helpful. And then last but not least, before we let you go, we want to take advantage of this cannabis expertise. Is chocolate better or gummies? No, I'm just kidding. Elizabeth would kill me if I actually had you answer that in a recorded session. But hey, Kristen, this has been delightful. Your depth of knowledge is terrific. Thank you very much for sharing it with us today. And we'll look forward to having you back very soon.
Thank you for having me.